Hello, my name is David Hodson. I am an English solicitor, mediator and arbitrator, and I'm a part-time family court judge in central London. I am a pure family law specialist working exclusively in international cases. I've been delighted to be involved in the family law section of the European Law Observatory for a number of years. I've been heavily involved in the arrangements for the UK leaving the EU in the family law context, and that is the topic of my talk today. I'm speaking from a PowerPoint which is obtainable from the European Law Observatory, alternatively from my firm, the International Family Law Group, but I hope it will be self-explanatory. And what I'm doing is I'm looking at the position of potential problems in practice. I do not wish to be problem-centered. I certainly don't wish to suggest that we've got problems in the way the work is going to be sorted out. But inevitably, there will be some practical problems which arise, and therefore in this seminar, I want to focus on them, perhaps to ask if there are certain solutions, perhaps to propose some solutions and find out perhaps some of the ways we can go forward. I've called it the end of EU family laws for the UK, but a subtitle, Overcoming Problems in Practice, and it is overcoming, which I think is the strong feature. First, some introductory remarks about what's happening. The UK left the EU on the 31st of January 2020, but to all intents and purposes, as a matter of law, the law continues until 11 p.m. on the 31st of December 2020. Existing EU laws continue, the European Court decisions continue, no change. And then at 11 o'clock, New Year's Eve, all EU family laws cease to have any effect, have any impact in the UK. One exception, domestic violence. I'll come on to that. We have no power to enter into international treaties, laws during this implementation period. We've had no involvement in any law changes. The most important document is the EU Withdrawal Agreement 2019, Articles 67 and 69. They provide that EU law continues in respect of all matters where proceedings were instituted, keyword instituted, on or before 31st December 2020. And it applies to all UK proceedings concerning an EU member state and all proceedings in an EU member state concerning the UK. In other words, the UK EU interface. And so what does that mean? So any order already made and any order made in proceedings instituted on or before the 31st of December 2020 will be recognised and enforced under EU family laws for any time in 2021 and onwards. And how long might this be? Well, this might be 20 years or more, 2038. There might be an order made today or next year in 2021 in proceedings commenced in 2020 regarding the arrangements for a child. The child may only be a baby. There may be a lot of dispute immediately, and that child arrangements order will still flow under EU law, Brussels 2, for the minority of that child. There may be a child maintenance order, child support, again made in relation to a baby, and again it will continue under EU law during the minority of the child. Maybe even longer. There may be a lifelong spousal maintenance order. England in particular makes orders for the lifelong spousal maintenance in some cases, and so that may continue for 20, 30 years, may be coming to an end before life long, but it certainly may be a 20 or 30-year order. There may be a divorce order that has been made and somebody wants to remarry 20 years' time in an EU member state, and they can, relying on the recognition of a UK divorce order, and of course vice versa. So despite Brexit, the UK and the EU will be engaging in mutual recognition enforcement for very many more years to flow. Now let's look at some problems in practice which will apply. Well, if there is a matter comes up in 2030, An issue that arises regarding recognition of a divorce order, more problematical, enforcement of child arrangements or maintenance. And by then the EU law has changed. Well, we know that Brussels II will be changed on the 1st of August 2022. Which law will be applied? Well, I don't know, but I think it's highly likely to be the law that is in force at that particular time. Are we seriously going to go back to the laws on New Year's Eve 2020, when the EU may have amended a Brussels II maintenance regulation several times before the law needs to be enforced? But I don't think that is completely clear. Another problem in practice, the UK won't be involved in any law reform, EU law reform. But if I'm right, and it will be recognition and enforcement under the law as it then is, we will be in the UK recognising orders under a law to which we are not now a party and have had no involvement in any of the reform measures. And then thirdly, on this particular element, problem in practice, given the UK decision to leave, is it really the case that EU member states will want to recognise and enforce our orders for another 20 years and more? I can hear the answer from certain parts of the EU already. So 3 problems in practice. Next, all that matters to gather this use of EU laws is that proceedings are instituted in the UK regarding an EU matter, in the EU member state regarding an UK. All that matters is to institute proceedings. And what does institute mean? Next problem in practice. EU member states have very different procedures about initiating proceedings. What does it mean? Does it mean you've got to serve? Does it mean you've got to take part in preliminary court discussions or negotiation or mediation? Is it when it's received at the court office, or is it actually when it's lodged and a stamp is put on it? I can foresee many disputes about whether proceedings were actually instituted on or before 31st December 2020. I think expert evidence may be needed. Another problem in practice here, the UK is amongst the most digitally advanced family justice systems around the EU. Many of our proceedings are now commenced online. Will this be sufficient for instituting in other EU member states? A matter for further discussion. Let's now come on to divorce jurisdiction. England and Wales has replaced Article 3 of Brussels II with fairly similar wording, but not exactly the same. Particularly it's the 5th and 6th indents, what we know as the jurisdiction of choice of the forum shopper. In England, we expect habitual residence on the day of commencement, and the 6 or 12 months ordinary residence. You'll remember the 6 months needs to be accompanied by sole domicile or nationality. 6 or 12 months ordinary residence. But I know very well that in a number of EU member states, the requirement is the habitual residence throughout the 6 or the 12 months. Next problem in practice. Despite a perception of continuing identical divorce jurisdiction, England and Wales is different, and crucially different on the basis of jurisdiction claimed by the forum shopper. So it means, in my understanding, London will remain available to families with a strong continental European connection, yet tactically arranging their affairs to be able to issue in England to their financial advantage. We have had a number of cases here in England, in London, where the whole connection of the family, the joint nationality, has been with another EU member state. But because maybe they've got a London property or they spend time in London or whatever, one spouse has been able to rearrange, maneuver so that she has got a sufficient connection in England to issue proceedings. That, I think, is going to happen and will happen even more. Will we accept that? How will that respond? I'll come on to that. Next, divorce forum. I appreciate that in EU laws, jurisdiction and forum are read together. In England and Wales, we look at them in different lights, different aspects. Divorce forum in Brussels 2 maintenance regulation is lis pendens. England and Wales has never liked it. It's been perceived as contrary to reasonable attempts at mediation, reconciliation, and avoiding going to court. And we will be replacing it in England and Wales with forum conveniens. With which country has this family got the closest connection? The law of the forum will be the law of the closest connection. And that will now be the law between us and all countries in the world, not just as at the moment between us and non-EU member states. But the EU will be maintaining its race to court. So, problems in practice, and I think these are going to be the most difficult. Let me go through 3 scenarios. First, and I use France, our closest neighbour across the La Manche English Channel. Divorce first in England, first in time in England. We're talking now 2021 onwards. Divorce first in England, second in time in France, but the closest connection is in England. England will expect to proceed. How would France or indeed any other EU member state respond? Will they say, but the proceedings were first in any EU member state in our country, and therefore we will deal with the matter, irrespective of it going ahead in England? Simply, lis pendens, France is the first country in Europe in the EU to receive the proceedings. On it goes, as with any other EU member state, ignoring that they're going ahead in England, which was first in time. Now, move on to another scenario. Divorce first is in England, second in time in France, but England now decides that France has got the closest connection. It says proceedings should be in France. Will France or any other EU member state then receive the proceedings, even though they may be second in time? I don't know. Will France simply say, no, we can't receive them. We are second in time. Third problem in practice in this scenario of divorce forum, which is, as I say, where I think most of the problems will lie. The proceedings are first in time in France and second in time in England. But England says we have the closest connection. And England, on a forum analysis, says it should be in England, not in France. There's a weak connection in France. Maybe they've not lived there for many years. 2 nationals from France have lived in England for 20 years. Property in England, assets are in England, work is in England. And so England says, well, it's an English case, we shall go ahead. But France says, we're first in time, we want to go ahead. Will France, or indeed any other EU member state, accept that England says it wants to go first, even though proceedings were first in the EU country? If they won't, how will England respond? And this is another scenario following from that. We have a respondent who has applied to stay, we call it, the English proceedings on the basis that England doesn't have the closest connection. But in the meantime, he pursues his own French divorce. Will England grant an anti-suit injunction? We call it a humane injunction, an anti-suit injunction. Well, we didn't when UK was an EU member state country, because it was not appropriate. It's inconsistent with a global European justice situation. But we will in other cases with non-EU member states. Will we in the future? I don't know the answer, but I suspect the answer is we might. I now come on to divorce recognition. About half of EU member states are signatories to 1970 Hague divorce recognition. The UK has encouraged the EU to encourage member states to join, but seemingly we perceive the EU has not done much about that. Problem in practice: will practitioners, please can practitioners across the EU encourage their governments to join 1970 Hague if not already a signatory. It must be beneficial that more countries are automatically recognising divorces granted around Europe. Next problem in practice. Is it really likely that an EU member state will refuse to recognise a properly constituted regular civil divorce from the UK, even if they are not a Hague 1970 signatory? We hope not. England is a very liberal jurisdiction when it comes to recognising foreign marriages and divorces. We do not expect an issue with recognising incoming. We hope there won't be an issue in recognising outgoing. May I now turn to maintenance? Similar provision as to jurisdiction regarding maintenance, needs-based claims. Similar position regarding forum. We still don't know, recording this mid-November, whether UK will enter the Lugano Convention. We asked back in April, but the EU has refused to say, apparently won't now be saying until sometime in 2021. We regard this as very unsatisfactory. It makes perfect sense that we join so that maintenance orders can be reflected. First problem in practice. Will EU member states recognise marital agreements with a choice of law of England? Now, that is not part of the English culture. We do not regularly have marital agreements compared to many countries around Europe, but we have some. Will they be recognised? Next problem in practice. How much do EU member states expect to operate bifurcation with the UK? Some part of the case, divorce in one country, maintenance in another, child support in one, sharing the marital community in another. How much will that still go on? Next problem in practice, do we need the Lugano Convention in family law? We have 2007 Hague Convention, works very well, works in a similar way, although it doesn't have the jurisdictional elements. Do we actually need Lugano? Some of the questions we're asking here. I think with children it is a significantly different position. There are far less changes in children law on the EU departure. Child abduction is primarily in 1980 Hague. Brussels II gave an overlay with some additional protections, but none are perceived as fundamental. The UK is a very fast jurisdiction, much faster than Brussels II recast will require. Recognition and enforcement of children orders across the EU will be satisfactorily dealt with in 1996 Hague. Jurisdictions found, of course, in Brussels too, but invariably based on habitual residence of the child, which is now the global criteria. We don't expect so many issues in children matters. But we do find an interesting situation in domestic violence. We have the EU Civil Protection Regulation, a really good piece of EU law that provides that civil protection orders made in any EU member state will be automatically recognised and enforceable around the EU, and is primarily aimed, of course, at land border countries. At a very early stage in the Brexit negotiations, our Prime Minister then, Theresa May, made a commitment and said, we will continue to recognise EU domestic protection orders in the UK. And so EU law, the Civil Protection Regulation, has been put into our actual national law. We will now, 2021 onwards, recognise and enforce automatically a domestic protection order made in any EU member state. The victims must have protection. Regrettably, the EU has not reciprocated. We've pushed them, but they haven't thus far. And so any UK civil protection order leaving the UK will not be automatically recognised around the EU. And we regard that as very unfortunate. Problem in practice. What can European practitioners do to help victims of domestic violence who cannot enforce UK orders in the EU, although can enforce EU orders in the UK? What can European practitioners do to persuade the EU to reciprocate so that we have mutual reciprocity? Let me part with a few final thoughts. I think it would probably be fair to say that the UK and the EU have had a fraught relationship in the family context over the past 15-20 years. We've had real differences on applicable law. We're a local law jurisdiction. We will not deal with applicable law. We've had major differences on marital agreements. We insist on disclosure, independent legal advice, quite a lot of regimes around it to protect what we perceive as the more vulnerable party. And yet, across much of EU law, it simply has to be in writing, nothing more. We've had differences on marital property regimes. We haven't opted in to the EU law in that regard, and similar elements. That hopefully is at an end. The UK and the EU together, however, represent a significant proportion of the world's financially independent, mobile independent international families. And so the laws of the UK, the laws of the EU are highly influential in very many countries well beyond ours. It must really be hoped that with these differences in the past, the UK and the EU can work together for the benefit of the global international family community and for global international family laws, of course, working with The Hague. Waxing lyrical, perhaps, Europe is the cradle of civilizations. Okay, India and China may have other thoughts. With a foundry upon which liberal ideas of justice, fairness, equality have flowed. Bravo! And there's much the EU can bring to future international family laws and global families, and much which the specialist UK family law profession can contribute to the EU as good supportive friends. The EU must find a way in which the UK, with our huge amount of international family traffic, can still have reciprocal recognition and enforcement. Laws which encourage racing to court, discourage mediation, reconciliation, they won't do it, but we must find a way forward. Whatever the political aspects of the UK leaving the EU, all concerned must work to the best interests of international families and their children. Crucially important. Thank you very much. Thank you very much to the European Law Observatory for giving me this chance to speak. If you're interested in discussing this or following it up, please contact me at the International Family Law Group in London, www.iflg.uk.com. And I and my firm can be found on the internet and certainly via the European Law Observatory. I hope to do a follow-up to this over the coming weeks to look at a number of key areas in which the UK and the EU can work together, about 6 or 7 of them, where I think it is vital that we work together for the benefit of beyond the EU, beyond the UK, for global families worldwide. There's a lot that we have got to do. For now, thank you very much indeed. Look at the PowerPoint, and I would be very interested to hear from family lawyers, family judges around the EU, around Europe, on your take, on your perception on how some of these so-called problems in practice will work out. The key is that we find a way to overcome it and we don't become problem centers, and I'm sure we can. Thank you very much indeed. Goodbye.